Well, Chuck, glad, sir, that you could join us on the program. It's good talking to you again.
Always a pleasure, Cam.
And what's the latest in the challenge to San Diego County's May issue permitting process?
Well, on December 14th, we got a ruling from the court, a very interesting ruling, saying that you'll remember that this judge had previously ruled very favorably to us when the county tried to get the lawsuit dismissed in the early stages of the litigation. Mm-hmm. And she acknowledged the Second Amendment right. She acknowledged the fundamental right to self-defense. She even went so far as to say that the allowance for unloaded open carry in California, where you could load the gun when there was an imminent grave danger, was not enough to satisfy the fundamental right to self-defense or the Second Amendment. But I think what happened here, we had a good judge. I think what happened here is she realized what a ruling would mean, what we were asking for, and she got cold feet because she basically backed away from the ruling that the unloaded open carry was adequate and held that, believe it or not, that carrying an unloaded, unconcealed firearm, mm-hmm. which the law allowed you to load when you are in imminent grave danger, satisfied the fundamental right to self-defense. Now, setting aside the open carry issue, which is not really the crux of this,
right?
I just went and saw True Grit this weekend, and in the words of Rooster Cogburn, an unloaded gun ain't good for nothing. I know that there are some listeners out there that love your show that have some experience in self-defense training, use of force training. I don't think you're going to get a lot of people that'll say, a lot of experts that'll say that carrying an unloaded gun mm-hmm. is a good self-defense strategy, and that relying on loading it only when you are aware that you are in imminent grave danger is going to be enough to give you a meaningful ability to defend yourself. You cannot, those kinds of seconds make the difference between life and death. And, for effective self-defense, it's simply put, your firearm needs to be loaded. I mean, it needs to be ready. So we filed a notice of appeal. Maybe the most interesting part of this is that what the antis are doing now, and by the way, the Brady Center weighed in on this case.
Yeah.
And I think that had something to do with where the judge was coming from. She realized that this was kind of a national issue. Their position now, the argument that they're trying to make, and it's not just the argument they're going to make in the Peruta case, they're making it in all their cases, is that all you have to do, all the county or a city has to do, is add some kind of a self-defense exception to a handgun ban. And then the law becomes constitutional. So they went so far as to say that if the Heller Court, and remember in the Heller Court, they originally, in the Washington, D.C., originally tried to claim that there was they originally said there wasn't a self-defense exception in the ordinance. Then they tried to back away from that and say that there was an implicit self-defense exception in the ordinance, mm-hmm. even though it wasn't actually written in.
Right.
Well, now the court is trying to say that because or the Brady Center and the gun ban lobby is trying to say that whenever there is a self-defense exception, the law is constitutional. So if there had been a self-defense exception in the D.C. ordinance that was challenged in Heller, they're trying to argue that the Supreme Court would not have overturned the law, which means that maybe where some of this litigation is going to go is to this type of determination on whether or not a self-defense exception in a statute is adequate. And I think that kind of shines a light on the Jackson case, which is a related NRA case that we have going in San Francisco, because that case challenges the San Francisco ordinance that requires your gun to be locked up in your home. And that's the same kind of, and now you can take it out to defend yourself,
Mm-hmm.
but generally you have to keep it locked up. So the question is, can you get to it fast enough? Heller talked about immediate self-defense,
Right.
not. And I was there. I saw Justice Scalia on the bench as they laughed about how long it would take to undo your trigger lock in the middle of the night so that you could actually make use of your firearm for self-defense against somebody who's breaking into your house.
I remember that discussion during the oral arguments. Absolutely.
So I think it's kind of, I mean, there are common sense and logical and rational and expertise arguments that can be brought against this kind of a claim that any self-defense exception, no matter how flimsy, makes a law constitutional. But the Brady Center and the gun ban lobby, they're bound and determined to make the courts go through that exercise, and we're still going to be up for some courts jumping on the excuses that the Brady Center is going to give them to not make the changes that really need to be made to effectuate a self-defense policy that works in California and in other states. So it'll be interesting to see how this precedent plays out in other states where you don't have the right to carry concealed or loaded. There is no or open, unconcealed. California is a bit unique in that it has the ability to carry an unloaded, unconcealed firearm on your hip. Some states don't allow it at all, and in those states, I think there's going to be a stronger. They're not going to be able to weasel out of the self-defense argument the way the Brady Center is trying to get courts to do now.
Yeah. Well, Chuck, this case has now been filed or appealed up to the Ninth Circuit. Is that right?
Correct.
Okay.
So we have our brief is due at the end of March. Whether or not we actually push it for then remains to be seen. There are a number of other cases working their way through the system. One of the issues that the Brady Center is also trying to make out of these public carrying cases is whether or not, believe it or not, they're trying to say that that the Second Amendment only applies inside your house, that you have no Second Amendment right once you cross the threshold of your home, which is, of course, ludicrous. And that's also something that I believe will be decided in the Nordyke case that we could be hearing any day out of the Ninth Circuit. That's already under submission about the ban on the possession of firearms on county fairgrounds in Alameda. Obviously, that's not inside the home, so the court's going to need to address that. It's also going to need to address the standard of review in that case. So there's a number of cases that are pending, any one or several of which might really move the jurisprudence down the line a bit that could be helpful for us in Peruta. Well, one of which is, as I mentioned, the San Francisco case, the Jackson case.
All right. Well, Chuck, it sounds like we are going to have the opportunity to talk to you quite a bit in the weeks ahead. I appreciate you coming on the program today.
You know what David Hardy said when Heller first came down was it's not the end, it's just the end of the beginning. There's still a lot of litigation that needs to be brought on behalf of gun owners and to advance the Second Amendment rights. The other side is, they have a lot of very smart lawyers. I have to give them credit for coming up with creative arguments to try and water down our fundamental rights. But the NRA and out here the CRPA Foundation are fighting back tooth and nail. We're not going to stop. We're going to keep taking the fight to them and advancing those fundamental rights for everybody.
Well, Chuck, again, keep up the fantastic work, sir, and look forward to talking to you again very soon. Happy New Year to you.
Happy New Year, Cam. Thanks.
Chuck Michel, California civil rights attorney, joining us here on NRAnews.com.